All right, everybody, welcome to the Saturday afternoon edition of the People Show. And this is the Legal Hour with Judge Leonard Murray, who will be joining me momentarily. I want to welcome you all to the program. And we're going to be talking about this. A lot of things going on, of course. Super Tuesday happened on this past Tuesday. We're going to be talking about that more on Monday. We may be talking about it a little bit, but today is the Legal Hour where you get to have your legal questions answered by Judge Leonard Murray. Anything that has to do with due process or something in housing court or even in the administrative review, if you've gotten red light camera ticket or speed camera ticket or citation on your property address or on your property or something like that, you will be able to talk with the judge as soon as that he joins us. Hopefully that he is. And of course, they are campaigning. He's also a candidate for the appellate court. So he is out working hard, and his punch number is 135. And certainly, we want you to support Judge Murray. You can go to his website at electjudgeleonardmurray.com. If you want to help the campaign, you can make a contribution there and get more information about the background on Judge Murray, who has just been a stellar person in the judiciary, somebody that I have come to know over the last probably 10 years or so. And we were fortunate enough. He married my wife and I 3 years ago, coming up this April. And so certainly appreciate him about that. His son is doing great work there on the south side of Chicago with the XS Tennis Village, grooming young Black boys and girls that have aspirations on becoming professional tennis players or just grooming them in the sport. It's a great sport. I've been playing the sport since I was 9 years old. So I've been playing the sport for a long, long time. And so he's got a beautiful facility there on the south side of Chicago. So while we wait for the judge to join us, I want to talk about a few other things that we're going to be doing today at 3 o'clock. Today at 3 o'clock, there will be a women's demonstration and press conference. Women for Flowers, Mary Flowers, because she's under attack by some of her colleagues in the General Assembly. And this is not about an ideology fight, but it's really more on principle. And so we're going to be with them today at 3 p.m. at the Brewers Coffee House, which is at 1008 West 79th Street at 3 o'clock. So we're asking for all of you who can, in particular women, to show your support and stand strong for Mary Flowers. Now, what they're doing, Chris Welch, Preston, Willie Preston, and Derek Curtis. Derek Curtis is the alderman. Willie Preston is a state senator who is a newly state senator running for his second term in office. They have basically ganged up and have brought in someone, and we don't know who their donors are. We're going to get that information to see who was funneling this money to them to put $1 million behind a candidate trying to oust Mary Flowers. We just think that the way that they're going about doing it is wrong. And so we're supporting her on that principle. We're supporting her on that principle and saying to them that this is wrong. This is not the right way to do it. And you cannot quash someone's freedom to speak, who is an elected official, to speak on behalf of the people that they represent, although that position may be different than yours. They still have that right, and that should be respected in the office. And to see that the Speaker of the House, Chris Welch, Willie Preston, and Derek Curtis taking this position against Mary Flowers purely for those reasons are unwarranted and frankly undemocratic. So, and we're going to challenge them. We're going to challenge them by supporting her. So we're asking for you to show up today, 3 o'clock, 1008 West 79th Street at the Brewers Coffee House to support State Representative Mary Flowers. We're standing against this type of oppression that is being perpetrated by the Speaker of the House, Willie Preston, and Alderman Derek Curtis. We're just not going to stand for it. I have my own issues in terms of philosophy about certain policies with Mary Flowers, but that is a different discussion, different argument. What they're doing here is just principally wrong, and I don't agree with it. So I'm standing with Mary Flowers, and I'm asking if you all would do the same thing. Join us today at 3 o'clock, 1008 West 79th Street on at the Brewers Coffee House, where we're going to be doing a press conference there at 3 p.m. this afternoon. And then later on today at 5 p.m., we're going to be having another 10 by 10 to win meeting at 5 o'clock, Zoom meeting. And that meeting, we're going to be talking about candidates. We're going to be talking about issues on the ballot and answering questions, giving people clarification on the transfer tax referendum, on the Board of Review, what's happening there versus what happens at the assessor's office, so that we can give you the real lowdown on what is happening there, so you know when you go into the ballot box what you're voting for or what you're voting against and who you're voting for when you go into the ballot box. So we're going to be talking about that this afternoon at 5 o'clock, and joining us on that conversation is going to be Commissioner from the Board of Review, Samantha Steele, who is going to give us some information about the inner workings of the Board of Review. So make sure that if you want to join us on that Zoom, that's a Zoom meeting. So if you want to join us on that Zoom meeting, we will put out the link so that you can join the Zoom meeting at 5 o'clock. So I'll put it out up on my page, and you can join in the meeting at 5 o'clock. We're going to have Commissioner Samantha Steele, who's going to be joining us at 5 o'clock. All right, so we're going to move right into our discussion. He is joining me now, Judge Leonard Murray, who is here with me right now, who just tuned in to this hour of the legal hour. We're going to be talking about some issues. We're going to talk about housing court. We're going to talk about the administrative review process. And any of you who have any questions, you can put them up in the chat while we are going through the program, and then Judge Leonard Murray will respond to your question. I'll read the question off, and he can respond to that question. How you doing, Judge?
Good afternoon, Mark. How are you?
I'm doing just great. Before we get into our discussion, I wanted to ask you, did you get a chance to watch the President's State of the Union address?
I watched bits and pieces of it. I was working on a document, so my attention was divided Thursday evening. So I didn't see it from beginning to end.
Okay.
But what can I say? I think it was the usual narrative that we've heard over the past several years.
Yeah, I thought it was a usual narrative, but I think that he again outperformed what many people were suggesting that he wouldn't be. I think he was, pretty forceful in his message, and I'm glad that it was not an elongated message, that it was relatively, shorter than most, but it was pretty succinct, and I thought he did a really good job of laying out what the binary choice is between he and the alternative coming up in November. And it's going to be incumbent upon us to put out the information of the track record. Because I think, from my perspective, I believe he's been a great president. He's far surpassed anything that I would have imagined that Joe Biden as president would have done. And I just think that he's done a great job as president. I put him in that category for me.
Well, I am a candidate, but there's a limit to which I can comment on.
Right.
That's not a state race, so I'm limited in terms of
Right.
how I can reflect on it.
Okay. All right. So let's get into our conversation. This is the legal hour. So those of you who have legal questions, put them up in the chat, and we will read your questions off, and the judge will respond to them. So I want to talk. Last week we were talking about, and I like to start right where you are. You're in housing court, and you deal with everything real estate related within the city of Chicago, and um, in terms of safety and those areas that people have to deal with. One of the questions that somebody asked me this week in passing, I think we talked about it, we briefed on it last week, is that they are getting fines for a lot. They're getting fines for a lot that that was given to them. The lot is not worth much money, but the lot was given to them, and people fly dump on their lot, and they have spent, several $1,000s of one fencing the lot in as what is required, but people are still fly dumping on that. But they're still getting tickets because of that, because they're not there every day. They don't live there. And so they get these tickets in the mail, and they go and they see that somebody has fly dumped on their property. What remedy is there for them, or is there a remedy for them?
What they've got an absolute right to defend the site against the citation. Uh, they can demonstrate that they're not responsible for the items that were present at the time the inspector drove by and noticed it. Uh, and in most instances, at least in my experience, that provides a sufficient defense to the citation. It's interesting, you did mention that that they fenced in the lot, because it's not commonly known that if you have a vacant lot, you have an obligation to put up a non-combustible fencing around it. And that's not something most people realize. And you can't be fined if you do not put up such a fence. But I think if they can demonstrate um, sufficiently that what the inspector noticed on the occasion when they were at the lot present there, because normally they document their claims and allegations with photos. But if they can demonstrate that this is not a result of anything that I allowed or was involved in, then that should be a sufficient defense to get beyond the ticket. Now, of course, they will have to clean it up, but it should be a sufficient defense for the citation.
Well, I have this person is a school teacher, and they had several $1,000s, I think almost to the tune of $11,000 in fines that they had, and they were trying to negotiate them. And when I got involved, I gave her information of what she needed to do. I said, one, you need to put a fence around around the lot, and then you're going to have to check the lot periodically, but you're going to have to clean it up, but you will have to check the lot periodically. And so we went down to 400 West Superior and tried to see if there was some way that they could negotiate eliminating some of those fines. They were not, well, especially knowing what her job was, it seems like they were not interested in um, any type of elimination of those fines, even though she was able to substantiate that there were old tires that somebody had dropped. It was clear that somebody had fly dumped garbage there, because she would have never had any need or cause to dump that kind of material there. They were not willing to do anything. What could she do from that point, if the city and the attorneys for the city were not willing to negotiate to eliminate any of those fines?
Well, she's got a right to defend it before one of the city's administrative hearing officers to determine whether or not they agree that she's responsible for whatever the citations that were issued against her for ownership of that lot. And then if she did not agree with that outcome, she's got a right to seek administrative review in the circuit court. Uh, as long as she files such a petition within 35 days of that order, that vests the circuit court with jurisdiction. And then that sounds like a case that would likely come to my division, the housing section of the circuit court. And one of the um, six judges who sit in that section, including myself, would review what occurred and determine whether or not we agree or disagree with the outcome as pronounced by the hearing officer that would have presided over those citations.
Now, being that you're the supervising job or judge for that department, do once they file that, do they all come to your courtroom first, and then their case, depending upon what they want to do, if they want to continue to try to appeal it, um, do they stay in your court, or do they, or is their case distributed to one of the six judges?
It's distributed. Well, I act as sort of an intake um, hearing session for all the cases because many times I'm able to solve it on intake so that we can resolve it either on that very first day because it's an inconvenience to folks to either come to court or try to be available for a Zoom hearing, which we use principally now. Uh, and there are many instances. Just to give you a quick example, uh, someone has multiple electronic tickets for running red lights, and they come in and explain that the vehicle was stolen and that whoever the person that stole the vehicle was the one who violated those various red light corners that generated the tickets because they're electronic tickets. They don't know who's driving the car. All they know is that the vehicle, triggered the electronic lighting system, camera system that exists around the city, and that generated the ticket and the notice. So if they come in on that first, and many times I do not understand why at the administrative hearing section, those tickets not resolved. If they come in and prove that there was a police report that supports the claim that the vehicle was stolen at the time of the alleged violation, it baffles me why those tickets aren't resolved and dismissed at that level, but many times they're not. So then they can file their petition for administrative review, do it within the 35 days allowed by state law. We will review it in circuit court, and many times I am able to resolve that case uh, on intake by setting an interim status date where they can send in their documentation to the court counsel's office that in fact the vehicle was stolen. There's a police report that exists that supports that claim, and they will agree to reverse the administrative hearing officer's ruling, and the case is over, and they're not fined. The fines go away. Um, so that's an example um, of what happens. But then there are many cases on intake that we need what's referred to as the administrative record. And the administrative record is everything that occurs following the citation uh, by the city, including the original citation itself, any documentation that the city may have submitted to support the issuance of the citation, including photographs, documents, what have you. Sometimes some of the issues that we get involved in, especially with fly dumping, is who owns the lot and whether or not the city has cited the proper lot, the proper specific address and location to support the citation. And there have been situations where we've discovered that, in fact, they've cited the wrong lot and the wrong owner. So, in those instances, likewise, we're able to do some preliminary um, exchange of information to demonstrate that, in fact, the person cited by the city didn't own the lot at the time of the citation. So, therefore, that's another example of cases that I try to get rid of and dispose of sooner rather than later. But then there we deal with Fourth Amendment issues related to impounds of vehicles following some citation or stop, a police stop, if you will, and you know, uh, the city ordinance in most instances is a strict liability ordinance. So it doesn't matter if you're not driving your own vehicle. If that vehicle is stopped because of an alleged infraction of some sort, then as owner, you're potentially liable for the fine that could be assessed for that violation. It does not matter if you are not operating the vehicle at the time of the stop in the alleged infraction. So those situations typically require that the full record be produced. And the city, as defendant in administrative review, they answer by filing the complete record. And in fact, if they don't file a complete record, that can be a basis for reversal.
Okay, and another question regarding the administrative review. So, if a person has sufficient evidence and they do go to the administrative hearing and the administrative law judge rules against them and they have to appeal through the administrative review process, the filing fees for those are $401.65.
Yeah.
If they came to the administrative review and they were able to substantiate that one or either of these, that they assign the ticket to the wrong lot and that's not your lot, which makes the ticket defective, and that you can, or they can demonstrate that while they have the lot properly secured as required by the city, somebody still went and dumped hazardous material on the lot, but they refused to dismiss it at the administrative law administrative hearing part. So now they have to come and have to pay $401.65 to be heard at the administrative review. If they prevail, at the administrative review, do they get those filing fees returned?
I if they prevail on administrative review, I always order refund of the filing fees because I think um, if the right right outcome had been realized at administrative hearing section, then there would have been no need to file the case, and therefore they would not have to expend it those funds in order to be heard to seek justice. So I always order a refund of those filing fees. Likewise, if the city and the party come to an agreement to settle the matter, I typically order refund of filing fees in that situation as well. And my rationale is that you really have not utilized the services of the court in adjudicating the dispute. So therefore, I think it's fair uh, that those filing fees also be refunded uh, uh, by the clerk's office, clerk and circuit court's office, to the plaintiff in that situation for the very same reason that they have not really utilized any services of the court in order to resolve the matter. The parties really resolved it between themselves.
Okay. The another question that came in. This question is from Willie. No, Mary Willie. Mary says that her home was foreclosed on, and her home was sold at foreclosure, or her mother's home was foreclosed and sold at foreclosure, and her mother only owed $46,000 on her mortgage at the time of her passing, and so when the home was foreclosed, it sold at auction for $78,000, and so there was a difference of about $30,000, give or take, for interest, penalty, and legal fees on that overage, or on that overage that happens at the judicial sale. the difference between what goes to the bank and that overage that goes into some escrow. I don't know if it's the clerk's office or who gets that office. What is the process of a family member or an heir getting those funds?
Well, let me just ask you, just in terms of the timing here. So, was the property sold during mom's life, foreclosed and sold during mom's life, or afterwards?
Well, she said her mother was deceased.
Okay. All right. So then it might be necessary in that situation to file, to open a probate estate in order to determine heirship. And then heirship then determines the distribution that's appropriate based on family connection. Um, if presumably dad preceded mom, and if the house is in joint tenancy, then of course, upon father's demise, then mom owned the house entirely herself. Uh, so then, if she dies without a will, then uh, the state law has a specific uh, uh, system of distribution to heirs. So in order to determine what that is, it may be necessary to open a probate estate so that those funds can be administered through the estate to those heirs who are entitled to it. Because sometimes you have siblings who die before parents and they have children. So then the children step into the shoes of their parent and would receive the parent's share, but not anything solely because of their relationship to grandma.
Okay. And what happens? Let's see. Okay, if a family member passes without a will or a trust, um, and the they want to turn the house over to another family member, what steps do they have to take?
All right. So then this is not an uncommon situation where you have a family member who dies and has not provided for a trust to determine passage upon their death, or otherwise signed a deed that could also uh, spell out what the succession rights would be. Uh, but by law, real estate cannot ever be unseized. So once the family member dies, then it automatically passes to those heirs without any legal mechanism at all. It's just automatic. The problem is that in many instances, um, the various entities that might be involved with respect to that real estate could be a mortgage company, it could be a lien against it. They won't acknowledge that uh, what the situation is without an estate being opened, uh, even in the presence of an affidavit. Now, what's interesting to me is that if the property were sold and you go through a traditional closing at a title company, uh, they normally will accept an affidavit from an heir demonstrating what the heirship rights are in that affidavit. Who mom or dad's heirs were at the time of death, and they'll facilitate the closing in that instance without opening an estate. But for some reason, if it's not involving a transfer of the property through a typical across the table commercial real estate closing, then you may well have to go through a probate process in order to deal with passing the property law.
Okay, so her grandfather died, and there are three siblings. She is the granddaughter. There are three siblings, and they want to turn the property over to her. The grandfather did not leave a will or a trust, and there is no mortgage on the property. So the property is owned free and clear of any mortgages or any liens. Um, do they have to open an estate to transfer that property from those from the deceased grandfather to his children, and then they transfer it to the granddaughter?
Well, again, the issue in that circumstance is what are the heirship rights that exist? So you mentioned grandfather, so presumably that meant that the father's children were deceased. So these grandchildren are taking through the rights that their parents would have had in the property.
Well,
So
the parent, no, the children are not deceased. Only the grandfather died. The mother and their siblings want to transfer the property to the granddaughter.
oh, I see. I see. So the parents are still alive.
The parents are still alive.
Okay. So then the parents could execute a quitclaim deed and transfer their interest to whomever they chose in that circumstance.
So they don't have to open in an estate.
Well, I think you would probably need to, and this can get complicated, but you probably would need to put something in the recorder's office to demonstrate what the heirship is. So you may well need to create an affidavit of heirship and record that along with the quitclaim deed to tie up the connection between the grandfather, uh, parent, and then the child to whom the parent wants to quitclaim their interest to.
Okay.
Otherwise, you've got a gap there between how is it that uh, the grandchild is entitled to the interest of a grandparent without connecting into that what the heirship was at the time, the grandfather's heirship was at the time of death.
Okay. All right. All right. Because as you say, it's not common. That's a very common problem, unfortunately, because in our communities, and I don't know, maybe in other communities, that many people don't set up wills or they don't set up trusts. And it sort of complicates the issue. But there are times where you have family members that are extraordinarily cooperative, and they want to take the path that is least resistance, and they all would want to quitclaim their interest to another party, right? And if there could be some mechanism that they could do that with affidavits or quitclaim deeds without having to open up an estate, that could save a lot of time as well as it could save the family money.
Right. And the issue in that situation is how is that this person who is executing the deed, how do they have a right to do that? And the only way to demonstrate that right is to show uh, once the grandparent died, who their heirs were.
Mm-hmm.
And then how that could then, because there's no gap in the season, as I mentioned, the property automatically passes to children or their heirs. So then a child can then deed their interest to anyone they like. But the question is, how did it? What's the basis for those rights? And the basis would be demonstrated by virtue of an heirship affidavit.
Okay. All right. So if I'm hearing you correctly, that the children, the property automatically transfers to the children of the deceased,
Correct.
right? But that has to be demonstrated by an affidavit
Yes. An
of that
heirship
heirship,
affidavit.
an heirship affidavit, and
Yes.
that has to be. Does that have to be granted by a court?
No.
Certifying that affidavit, or no?
No. No. Affidavit is something that you would sign before a notary public.
Okay.
That makes it a sworn statement. But that it can be a rather elaborate document
Mm-hmm.
in that you've got to show, for example, that the deceased grandparent um, who they were married to, if there were any other marriages involved, so that you eliminate the potential for other heirs
Hmm.
outside the typical family tree. And you got to have someone who's familiar with the family tree in order to create a really complete affidavit and thorough affidavit that explains how it is that title or interest in this property now resides in the people that are attempting to transfer um, an interest in it.
And that process could take how long?
Um, it's not it can be quick. It just depends on whether the affiant is sufficiently knowledgeable about the family tree. But once the affidavit is created, along with the transferring instruments, normally a quitclaim deed, uh, you go through the process of recording it through the Cook County Clerk's Office, um, and providing with to them the documents that they want in order to accept uh, these instruments from you. Sometimes you may need transfer declarations for both the state, county, and city. But short of that, it can be fairly quick. It just depends on um, just how knowledgeable the affiant is about the affairs of the family. And maybe it may well be that you may need more than one affidavit, someone to fill in the gaps that you don't know about.
Okay. All right. That's good information. So hopefully that helps you and that could save your family a lot of time. So if you can find out that information, you may not have to go and open up an estate. And as long as the children can prove and they know about the family dynamics there, you all may be able to transfer that without having to open up an estate. So hopefully that answered your question. I get that a lot. I get that a lot because as a private lender, people call me and say that um, they have a family property, a family member passed away, and there was no will, there was no trust. I usually tell them you should probably go and consult an attorney who can help you through that process. It's worth paying a few $100s for you to make sure that you get this right and you do it the right way. So that is great information that people, a lot of people can benefit from that one question because it is a very common situation that happens because we just, our parents and our grandparents don't set up trust as well as they don't trust having somebody else on their deed while they're still living, even if it's, their children that they intend on leaving it to. So that will be helpful information that we could pass on.
And that's also a risk with the power of attorney for property. Um,
Hmm.
I had a case before I became a judge where the daughter had uh, used a POA to place a mortgage on her dad's house, unbeknownst to him. And because of the way the POA was drafted, power of attorney was drafted, it gave her the authority to do that. And it was a total mess. Then, she didn't make any payments. The house was subject to foreclosure. Uh, and it was a family disaster for them. And ultimately, this man who worked hard all his life had in fact paid off the mortgage to his house, uh, was forced to obtain a reverse mortgage in order to be able to maintain residing in his own home. And what really got me is that the daughter seemed to not have any shame about what she did there. It was just abominable, I thought.
Well,
Um,
did she? What now? Did he give her the power of attorney, or did she make up the power of attorney on her own?
she created it or had someone draft it, and
Hmm.
and then gave it to present it to her father to execute, suggesting that if the problem comes along, I will have the authority to deal with it for your benefit. Well, the benefit that she was looking for was her own, where
Hmm.
she then obtained a mortgage against dad's house, unbeknownst to him, received all the proceeds of the loan, not one penny benefited him. And then once he became aware of what occurred, uh, the only solution was to uh, go out and get a reverse mortgage because he didn't have any of the resources to try to deal with it. The daughter had no shame. She didn't pay a single mortgage payment. In fact, didn't even tell her dad about it, but thought because uh, she was, I think there are two children, so because she was one of uh, his two children, that ultimately the value of the house would be something that she would receive. So she's now getting it now, rather than waiting to his demise. And the other complication here is that dad had remarried, so he was then living in that home with his new wife, and the foreclosure had the possibility of putting both of them out at that point.
Hmm.
So it
So,
was just,
it
it
sounds a
was a
little
terrible
criminal to me.
situation. You know what? I thought it was as well. It angered me that she would just have no shame in what she did. She defended it, which I just thought was crazy.
Yeah, because it seems to me that if you are, it's a sworn statement, right? That you're signing this document that it will be used in the event of an emergency on the behalf of her father. That's the purpose of the power of attorney. So the only reason that you would use it is so that you could get resources to take care of his needs.
Right, and
And the fact
and
that
he had no needs. It
he
was
had
a
no
healthy.
needs,
It was a
that
healthy
she went
marriage.
in, right. So it would seem to me that at that moment of executing that, it seems rather fraudulent.
Uh, we fought it, including litigating over it. But none of the judges that I raised the issue with would agree with Dad's side of the story, and ultimately believe that he had um, voluntarily executed the POA, uh, which he did, but it wasn't for the purposes of allowing his daughter to then go out and borrow money. She claimed he did. He said he did not.
But I guess those exceptions probably were not noted in the POA,
They were not.
the specifics. It
Right.
was
They were
just a
not.
general POA that she could use this for his needs. And so it's kind of hard for the courts to be able to interpret who was right or who was wrong in that instance. It made it very difficult for the courts to be able to make that distinction.
Right. The other thing that's important is, once having executed a POA, uh, as the person who's granting the authority, how do you take that authority back? Uh, because this person is walking around with this document that suggests that they have the authority to do the acts enumerated therein. But how do you give public notice of the fact that you are withdrawing that authority now? And I think it requires actually putting out a public notice that would constitute constructive notice to anyone who might rely on it. But that's a difficult situation as well. Once having created a POA, giving that authority to someone, how do you then take it back? And that's an important consideration because you may well change your mind about what you've done. So how do you undo that?
Right, right. Um, yeah, yeah. We can. Yeah, it's that makes it that raises some question. And how do we educate people to make POAs specific?
Yes.
Right?
Yes. It
They
should
should be
not be
specific. It should not be a general POA. It has to
absolutely
be
not.
specific.
Yeah, and not just for property, so also for healthcare.
Right.
That's also very important area to be specific about in terms of what you want to allow someone else to decide on your behalf.
Right. And speaking of healthcare, a question of a POA and healthcare. Um, POAs are not general. They're not general to because somebody signs a POA, that means that you have power of attorney over everything.
Correct.
POAs are pretty specific. Is that correct? There's health, financial POAs. They're not one and the same.
Right. The financial POA usually referred to as property,
Hmm.
and that which deals with healthcare is in fact a power of attorney over healthcare. So they are different, and
Right.
there's not one document that can accomplish both.
Right. Some people have folks who have been under the idea they get a medical POA if they have a person that goes into the hospital because the hospital has to have somebody who can make decisions. So they do, especially when the person are not able to make that decision themselves. Whoever the next responsible person is, that person has to sign a POA so that the hospital has somebody that they could speak to that could give them direction. But that is specific to that person's medical situation and not to all of their medical and property.
Yes, yes, it should be something that's well thought out and something that you feel um, in the event that you become incapacitated and there's a need for someone to make some very vital, important decisions, uh, that you get given clear direction in terms of what your wishes are during those moments.
And in the cases where they're not, when people are incapacitated, the hospital still has to have a medical power of attorney to make decisions, which is why people talk with your family. People should have these conversations. They should sit down and they should have these conversations because we all have to make a transition out of this life. And hopefully it's much later than sooner, but it's going to happen. And we should be having these conversations and put things in place, even if it's something very, very simple, but you put something in place so that you have something in place rather than nothing in place, because having nothing in place, it brings out the worst in family members that they never would have imagined would be there. Because you don't have that one document in place that could be the direction of what you want done with your property. I remember when I was in school, it was said, the professor would said that even if you have, two pencils and two cartons of paper, write it down somewhere what you want to happen with your pencils and your papers so that people are not fighting over the pencil and paper. Just write it down on something.
Yes, there's some tremendous family feuds that occur when there's anything to split up. And as that professor wisely suggested, even if it's a couple graphite pencils and blank paper, there could be a fight that ensues to see who gets it.
Yeah. Yeah. So, all right, folks. So make sure that you all get with your family members on these issues because these are important decisions that you have. But I think that these are also important. I think one of the most important things is that people have heard there is that you don't always have to, even if you don't have a will or you don't have a trust, not in every instance that you have to open up an estate. If you have a clear way of determining the, I guess, the rites of passage there, you could avoid having to open up an estate and go through a long, drawn out court process and cost.
Yes, yep, can be expensive.
Yeah, yeah. So, all right. Let's let's I wanted to cover housing, and I wanted to cover the administrative process, and then somebody started asking questions about that, which are, very, very important questions. um, Now somebody is asking a question about bankruptcy. they have they have a number of tickets and fines, and they wanted to know that if they filed a bankruptcy, does that eliminate their tickets and fines to the municipality?
That's a good question, and I'm not clear on what the answer is. I may need to defer on this to next week. But uh, there's some argument that there was a provision in the law that changed that no longer provides an escape through bankruptcy for example, typical parking tickets or red light or speeding tickets for an individual. That they do go forward beyond the filing of a bankruptcy. So I would really need to. I know the city in some instances takes a position that uh, that the filing of bankruptcy does not stay efforts at collection. Under the bankruptcy code, there's a section 362 that acts as a stay against any action against you pending the outcome of the bankruptcy, unless the claimant comes into court and files a motion to modify the stay and grant relief, get relief granted that allows them to continue to pursue their claim elsewhere. Um, but beyond that, the issue is whether or not mere filing of the bankruptcy does stay, for example, the city of Chicago from attempting to go forward and deal with those issues. I need to get some clarity on that because it's I'm hearing two arguments. One that of course, city's just another claimant; they're not special in that regard, um, and then others who say. Um, the Corp Counsel's office saying, well, yeah, we are special, and that we're not subject to the stay that's in effect against most other claimants. So, if we can hold that in abeyance till next week, and I'll get a definitive answer.
Okay. All right. So next week we will address that question. I'm making a note of it so that we will be able to come back and answer that question for you. Related to bankruptcy. I do know that there was some action taken related to that, but I don't remember it clear enough to even to talk about it. But we're going to address that next week. So make sure that you tune in next week so that we could the judge can respond to your question relative to tickets and bankruptcy. I do know that if you have student loans are not subject to bankruptcy. It's the one thing that is not subject to a bankruptcy. If you file a Chapter 7, it's not subject to a bankruptcy.
Right.
Uh,
Yeah.
uh,
The law changed. Let's see. I think with the bankruptcy code, I want to say 2003, but don't hold me to that. But it specifically eliminated student loans from being subject to discharge in a bankruptcy. And the reason is because you might imagine you could get the benefit of these loans, which are intended to help and assist folks with paying tuition costs, uh, gain that degree, go forward in life and not have to repay that debt, which could be several tens of thousands of dollars. So it would be a big boost to one's financial position if they didn't have to pay those costs, repay those costs. But that's no longer the case. Student loans are no longer dischargeable in bankruptcy. In fact, I'm trying to think now. I had a case that we just barely made it under um, the timeline for filing the case and being able to discharge student loans in bankruptcy.
All right, we have a few minutes left. I want to talk about the this situation. You and I had a conversation about this. I know now of two incidents where there are two people who are in foreclosure. They're in foreclosure, and their properties have not yet gone to the foreclosure sale. Well, one has gone to the foreclosure sale, but it hasn't been confirmed. The other is going through the process. However, in the interim, the bank has sent these um, their agents of their housing preservation people to go to essentially break into the house and change the locks on someone's property that they still rightfully own before it's been fully adjudicated. What remedy does first of all, a um, is this a crime that is happening by these banks sending these preservation companies to do this? Now, the preservation company has no idea that the person hasn't lost the home. They're just assuming that if the bank is sending them out there, that the bank already owns the property. What's the remedy to that?
Well, it would be a trespass, I believe, because um, those persons present on the property have no right to be there, even though they're acting on behalf of their principal. In that case, their agent for principals telling them to go undertake this action, but there's not the legal authority uh, to do so. So it is a trespass. What might occur is that once law enforcement comes out and discovers what occurred, they would probably uh, direct those persons off the property. But I don't know that they would charge them, since there's no state of mind on behalf of those agents that to violate law, if you will. They're really merely carrying out a commercial act on behalf of their principal. Um, because the mortgagee in that case would have no right to enter the property at that point, since they're not the title holder. So, short of maybe having some interlocutory order from the court that says, in order to avoid any additional waste at the property, for example, if it was vacant, uh, and running water was occurring in a property, or something of that sort, it's doubtful that a court would allow a mortgagee to have authority to enter the property, short of maybe the need to undertake an act to preserve the integrity of the property.
And at that point, they would have a court order to enter
Exactly.
the property. They would have
Exactly.
a court order. All
Yes.
right. So that was a brand new situation that has happened on two different occasions. I know I spoke to you about one, and I contend that if it's happening to one or two, this must be happening to several, and people just are not aware of what their rights are. So you do have rights until it has actually been confirmed by a court. You still have rights, and then even after that, depending upon the circumstances, the court gives you 30 days to redeem if in fact it is your primary residence. So all right, make sure that you consult an attorney on any of these matters. The judge is here to answer questions as it relates to the judicial process, and as well as your legal issues. He's not here to give advice, but he certainly can answer these questions. We'll be back next week with another edition of the Legal Hour with Judge Leonard Murray. And also, Judge Leonard Murray is running for, he's a candidate for the appellate court. And your punch number, Judge, is
135. Don't be in a hurry. Vote for Murray.
Don't be in a hurry. Vote for Murray. All right. The judges are always at the end of the ballot. And so don't be in a hurry. Make sure you carefully go down through the ballots and make sure that Judge Murray is one that you support in this upcoming election. All right, Judge Murray, thank you so much for being here. We'll see you next week at the same time. I know you got to get out on the campaign trail. Things are going well, I'm sure.
I'm hopeful. They don't do polling in judicial races typically. You really don't know the outcome till election day. We're optimistic about our chances to be successful here.
All right, fantastic, Judge Murray. Thank you so much. We'll see you next time.
Okay, thank you, Mark.
All right, folks, look, that's going to do it for us this hour. Listen, I want for everybody to make sure that you join us at 3 o'clock. We're going to be over at the Brewers Coffee House at 1008 West 79th Street at 3 o'clock. Meet us over there to support Mary Flowers against what we believe is just principally unconscionable, that you have people who are trying to gang up on her, so to speak. And we're talking about the Speaker of the House, Chris Welch, Willie Preston, and Derek Curtis, all of which should be ashamed of themselves. And we're not going to allow this to stand. So what we need is we have to mobilize ourselves around this issue to say, no, we're not going to stand for this, as well as some other things that are happening that we are dealing with. We're going to talk more about that. Some of you may know about what is taking place out in the suburb of Flossmoor, and we are supporting the chief of Flossmoor out there and standing against what we believe to be an unjust prosecution in terms of trying to oust the chief from his job. He's the first Black chief elected in Flossmoor, and so we stand with him in support of making sure that a fair process moves forward, as well as to maintain his reputation. So we'll give you more information about that. I'm sure some of you have seen it in the news. There will be more information coming forth in the coming days. So stay tuned for that. All right, that's going to do us for this hour. I'll be back tomorrow, or I'm going to be talking with the Board of Review Commissioner Samantha Steele. That will be on a special podcast tomorrow afternoon at 3 p.m. So make sure you tune in for that. Tell your friends to tune in. Facebook Live, YouTube, Instagram, and X, formerly known as Twitter. So we'll be doing that. And of course, you'll see me right back here with David Orr on Monday. Several different podcasts. I told you we're going to be doing several podcasts throughout the election cycle, all the way up to the election in November. This is a very critical time. So we want to make sure that we put out information, put the facts out to you so that you'll know what is what's real, what's fake, what's false, what's phony, and why it is important for us to make sure that we play the long game for our communities. There are some great things that are happening coming out of this administration, and we want to keep that process going and that progress going, because it certainly will benefit Black people and is benefiting Black people in this country. 200 and some odd thousand jobs a day being created. Black people are getting some of those jobs who didn't have a job before. So let's make sure that we are informed and as we are making our arguments, making our decisions on who we are going to support, because there's a binary choice coming up in November between Joe Biden and the alternative of Donald Trump. And Donald Trump is not what we would contend to be progress. Look at the records, look at the facts, and make your decision. All right, that's going to do it for me. I'll see you guys in just about an hour. I'm going to get ready. I'll meet you over on the west side, 1008 West 79th Street. That's at the Brewers Coffee House. Meet me over there. Let's go and support Sister Mary Flowers against another act of injustice. And then I'll see you right back here tomorrow at 3 p.m. Take care.